Welcome to today's session. It's a great way to celebrate Privacy Week. We can catch up on some of the changes now that they've bedded in a little bit. I'm Hayley Miller, if you haven't come to one of my sessions before or haven't met me. I'm a specialist commercial partner here at Dentons Kensington Swan, and privacy, TMT, so tech, media, telco, and consumer law are my thing.
And g'day everyone, my name is Campbell Featherstone. I'm a senior associate in the Wellington office at Dentons Kensington Swan. Some of you may remember me from my contract drafting workshop from a few weeks back. So I'm also a commercial tech and privacy lawyer and consumer lawyer. Look, today we'll do our best to answer questions as they arrive during the course of the webinar. We have a Q&A function, so please submit your questions through that. If we don't get address your question during the session, we may try and do so at the end, but in all likelihood there'll be quite a few questions. We might have to respond in writing afterwards to some of the better ones, and we'll circulate that to everyone. And yes, a recording of this webinar will be made available afterwards as well, so if you do miss anything, you get a chance to watch this again. So just a bit of a summary about what we're going to talk about today. We're going to start with a reminder of some of the key changes of the Privacy Act 2020 and what they've meant since they've come into force since the 1st of December last year. We're not just going to cover what the changes are, but we'll also take a bit of a look at how they've been experienced in practice since the new law took effect. And then we're going to do a bit of a deeper dive into some of the provisions you should be thinking about when entering into an agreement with a service provider who's going to process personal information as your agent. So that could be one of the key areas of risk for an organisation when you're engaging service providers to deal with personal information on your behalf. And we'll finish up with some bonus topics, including a very quick scan of what's going on in Europe, which includes, while it's no longer part of the EU, the UK. So just to start with, and by way of a bit of a reminder, what is the new Privacy Act all about? So the Privacy Act 2020 has been described as a bit of an evolution in New Zealand privacy law rather than a revolution. So the core of the Act, which some of you will be familiar with, the Information Privacy Principles, or IPPs, we'll refer to them as, they haven't actually changed that much, and there's only one new one, which actually suggests that they were quite good to begin with. So drafted and came into effect in 1993, and they've managed to survive the last 27 years and adapted to changes in technology over time. And that's one of the benefits of taking a principles-based approach rather than being overly prescriptive in terms of privacy law in New Zealand. But the new Act's been several years in the making. There's been a number of reports about the 93 Act over the years. And we now have a new Privacy Act, which perhaps doesn't go far as the Privacy Commissioner wishes it would. In his stated view, we now have a Privacy Act that's fit for 2013, so maybe 7 or 8 years out of date already. So watch this space, there could be some more changes to come. But what does this mean for you? Well, it means for the most part, you've actually had about 27 or 28 years to get things right before the new Act came into force. And now that the Privacy Commissioner does have some enforcement powers, you can expect him to take some action. So previously, before the 2020 Act came in, he liked to state that he only had gums with which he could exert some pressure, no teeth. So now under the 2020 Act, he has some baby teeth, especially by international standards. That means that he can enforce some aspects of New Zealand privacy law a bit better than he could previously. But I say baby teeth, certainly by international standards, the powers and the potential fines and exposure are not quite as significant as, say, under the GDPR, where the highest fines for the most egregious behaviour are the greater of 20 million euros and 4% of global turnover. We've seen some pretty big fines over in Europe for privacy breaches. And that's not to say that you won't get a little bit of leeway coming into the new Act. I suggest that you check out the Privacy Commissioner's Compliance and Regulatory Action Framework, which covers the compliance intervention options that he and his office have in terms of privacy practices and privacy breaches. And there's a real focus on educating and advising and encouraging compliance with the tools that he has available to direct and enforce privacy law only coming in the worst case scenarios where the other tools aren't working. But what does it mean for you, this new Privacy Act that's come into force at the end of last year? It's an opportune time for any organisation to consider the practices and policies that they have in place. So it's a good impetus to rethink your privacy practices. Even if you think you've been doing it right since 1993, it's fair to say that best practice has moved on. an opportune time to think about how you can embrace a more consumer-centric privacy by design model when it comes to designing your processes, your products and services to make sure that you keep privacy front of mind and the consumer's interests at heart. And in that regard, it's important to not forget that compliance with privacy principles, it's not just about legal compliance, it's not about compliance with the Act all the time. Consumers are becoming way more attuned to the importance of their personal information and their online identities. They're actually looking at how organisations respect their personal information when making purchasing decisions. So demonstrating that you keep privacy front of mind may actually give you a competitive edge. And there are massive reputational risks as well of poor privacy practices, especially in terms of privacy breaches, which have a significant impact on customers. So a privacy breach can lead to not just regulatory action from the Privacy Commissioner, but you need to think of also potentially lost customers, lost revenue, direct costs that you might incur in upgrading systems or processes that perhaps weren't designed with privacy in mind to begin with. And a classic example of this is an ISP in the UK called TalkTalk, which suffered a massive privacy breach. They were fined £400,000 under the pre-GDPR regime in the UK. But as a result of the breach, they lost over 100,000 customers. Their revenue went down by about £60 million. And they incurred about £40 million worth of IT costs fixing the problem. So that just goes to highlight that it's more than just the compliance, the strict compliance with the law that's important.
Thanks, Campbell. So let's start by taking a look at the new IPP, IPP 12. Now, usefully, they've thrown it in as 12 and not 13, just to keep us all on our toes. So what was previously 12 is now 13. Now, this IPP seeks to strengthen protections with respect to the flow of personal information on a cross-border basis. But the first myth that we need to remove on this one is that it's not just about, it's not focused on where the data is moving around to, but to whom. So it catches transfers to foreign persons or entities. So that's the first thing to note. Now, in addition to pure third parties, it may well catch intragroup transfers. And we've been working with a number of corporates on tweaking their worldwide data protection type intergroup agreements to accommodate the New Zealand requirements. And generally, it's not a big shift. It's just making sure that it also captures the specific New Zealand requirements. Now, it doesn't apply to a transfer of information to offshore cloud providers and other offshore agents. And this, of course, is for the purpose of Section 11 of the Privacy Act, which, again, it used to be a different number. So that's the one that talks about acting as your agent. This reflects the Privacy Commission's state of view, so it is pretty settled that offshore cloud providers and other service providers that are acting as your agent don't trip IPP 12. In this way, it's different to the GDPR and UK data protection laws, though they specifically do cover offshore processing and have requirements around it. So if a disclosure of personal information is to be made to a foreign person or entity, there are a number of different ways in which the disclosing party can establish an appropriate basis to essentially tick the box on IPP 12. But before you even go there, it's really important to remember IPP 11 and how that applies. That, of course, is the general requirement to ensure that you've got a proper basis before you do any disclosure. So you need to establish that. And part of that being an important step is that IPP 12 actually only applies to some, not all, of the IPP 11 grounds. So depending on the ground that you are doing the initial disclosure for, you may or may not have to comply with IPP 12 as well. So for example, if the disclosure is to the individual concerned, it doesn't trip it up, or where the disclosing agency believes on reasonable grounds that the source of the information is publicly available publication, and that in the circumstances of the case, it wouldn't be unfair or unreasonable to disclose the information. Another exception to having to trip up IPP 12 is if it's necessary to enable an intelligence agency or security agency to perform their function. So yeah, do work your way through and always remember IPP 11 as well. Having said that, if you do actually get to IPP 12, there obviously are some main bases here. The most obvious one, authorization, actually is not quite so brilliant to have to trip up, so we'll go through all these in a bit more detail. But you've also got prescribed countries, schemes, Act already applies, if there's comparable safeguards, or if they're required to protect in a comparable way, for example, and the example is specifically given in terms of some sort of contractual obligation. So we'll go through each of these and see where they're at. And I guess the short point for authorisation hasn't changed much since I spoke to a heap of you at the end of last year. It has to be very, very express. So having it hidden away in your terms and conditions, bundled with other terms, isn't going to cut it. This is certainly a much higher level of authorisation than we are used to under the Privacy Act. And essentially I would have it in flashing lights if you're going to rely on this. As a consequence, it's pretty rare that we've seen in the last 6 months with our clients relying on this one. It's more a one-off case. This might be what you'd lean on. Most marketing departments would not be happy with the level of legal authorisation we'd be wanting. So practically and for commercial issues are unlikely to be a very well used basis. Prescribed countries, well, this is a bit like the European Commission's whitelist, which a number of you will have heard of, I'm sure, or at least it will be once we have some countries added to it. As indicated last year, it was going to be pretty slow in terms of rolling these out, sadly. I think a lot of clients had hoped middle of last year that prescribed countries was going to be a really useful ability to get compliance underway. Still none. The Ministry of Justice consultation anticipates 1 or 2 countries assessed annually. We haven't heard of which one's going to be first off the block. Happy to start a bit of a poll, perhaps, a sweepstake. Australia probably is a likely contender. EU, UK potentially as well. Yeah, my money's probably on Australia, given the proximity and trading partner status, but we'll have to wait and see. Now, the next one is prescribed binding schemes. Now, these are a bit like binding corporate rules. Again, it's coming over from sort of the land of GDPR. Again, there's none at this point, so not a helpful basis still. We haven't heard anything more really on this one either. But it could be part of multinational group arrangements, essentially, but they do have to be prescribed. So there's a process that we'll go through, but none to date either. The next exception is where the Act already applies. And this is essentially, notwithstanding that it may be a foreign entity, if that foreign entity is doing business in New Zealand, they may already be captured by the Act. And we're going to talk about extraterritorial application shortly. And that test would be where you'd be wanting to rely on. Essentially you're saying, okay, yes, they're a foreign entity, but they are subject to Privacy Act in just the same way we are. And so we're comfortable with that disclosure. But obviously you have to be careful what you wish for. If you're relying on this ground, you are accepting perhaps the counterparty is subject to New Zealand law and they may not want to be. So yeah, just being careful, especially if it's an affiliate, simply just relying on this, you do need to obviously look at both sides of the coin. The next basis is comparable safeguards, and you need to establish a reasonable grounds for believing comparable safeguards. This does involve going through an assessment, and we've been doing this for a number of clients who had been waiting for some of the lists to come out of safe countries, which essentially didn't happen. And so getting an opinion or doing a legal opinion internally, going through an assessment and essentially comparing the laws and coming to a grounds that you do believe it's comparable. Obviously, to do this, you need to understand the laws as they apply to the recipient. So if you're comparing to Australia, obviously you need to understand Australian law. And for example, with Australia, there's a threshold for small businesses and an exclusion of employment records from the federal privacy law over there. So things are not going to be exactly the same. And depending on the nature of the information that's being transferred, you may get a different answer as to whether or not you think it's comparable. Finally, the model agreement. Now, in terms of this basis, obviously you don't have to use the model agreement. It's been an interesting guide in terms of what's expected. Essentially, it is full compliance with the New Zealand Privacy Act. Now, the model clauses are just one way of putting that into place. They're drafted as though they're a separate agreement that sits alongside. You certainly could incorporate those. You could incorporate them perhaps as a schedule. You could incorporate them potentially by reference as well. And you may not want to use them. You may just want to rely on your own drafting and clauses. But essentially you are requiring that the recipient that you're disclosing to will essentially comply with the Privacy Act or similar requirements. In any event, the OPC has published some great guidance around this. There's a link there, and obviously you can always come and talk to us as well.
Okay, so I'm going to talk a little bit about the notifiable breach regime, which has now come into force. So we've had a few months now to experience what that means in terms of practice. And helpfully, because it is Privacy Week, the Privacy Commissioner published a nice infographic with a rundown on some stats about notifiable breaches. So very timely. So by all accounts, 76 serious privacy breaches were reported to the Privacy Commissioner in the period up to 31 March. And 84% of those involved information that was sensitive or likely to be sensitive. But interestingly, of those privacy breaches reported, 25% were a result of email error. So what that means, it's primarily human error. It's more or less attaching the wrong attachment to an email, or it's sending an email to the wrong person. So it really highlights that privacy compliance is not just about IT security, but it's also about those organisational measures that we need to have in place to ensure that we can eliminate privacy breaches from day-to-day operations. There have been a number of high-profile breaches in the media during the first few months of the year. We've been involved in helping some clients respond to those. And the key that we've found is to engage with the Privacy Commissioner in his office early and openly. The Privacy Commissioner is here to help. And his office is there to provide some useful guidance and assistance and a view on the best way forward. They're not there to punish you. They're not there to wrap you over the knuckles. They do actually ultimately care about the individuals whose privacy has been the subject of the breach, and they want to mitigate the fallout for those individuals to the best of their ability, and we'll work with you in order to do that. And it's ideal to engage with the Privacy Commissioner early and openly because, of course, in terms of the Act itself, the penalty in the context of notifiable breaches, that arises if you don't notify the Privacy Commissioner when you're required to do so. And we'll cover that off shortly in terms of when the situation does arise. There's a question of whether or not, you should be better safe than sorry and notify even if you don't really think it is a notifiable breach. Certainly there will be a lot of that in the early stages, and by all accounts there has been quite a bit of that. Although fortunately, or perhaps maybe it's either a case of people taking a pretty objective and thorough process before they notify, or perhaps not being aware of the obligations. But by all accounts, the number of notifications received by the Privacy Commissioner has not been as many as the office thought it would. And maybe part of this is because the Privacy Commissioner's office has put together a pretty useful tool known as Notify Us that enables anyone to get a really good feeling for whether or not a report is necessary. So useful, I think, to check that out, have a look at what it looks like, and probably do that before you have to use it for the first time in an urgent situation, so you're familiar with what the guidance is. You don't want to have to be scrambling around if a breach were to occur, having never come across the tool before. So just by way of reminder, we're going to cover off both what constitutes a privacy breach and then what meets the threshold of a notifiable privacy breach. So the definition of a privacy breach, it should be fairly obvious, or at least the large chunk of the definition is fairly obvious. It's the unauthorised or accidental access to, disclosure, use, modification, destruction or alteration of personal information or other misuse of the personal information. So that doesn't necessarily require an IT security hack. So if you're misusing the personal information that you've got, that still constitutes a privacy breach. It doesn't require sort of third-party bad actors to be involved. So you do need to keep that in mind in terms of your internal processes. And what it also covers is an action that prevents the entity from accessing the personal information on either a temporary or permanent basis. So there's a few things to think about there. One is the need to perhaps consider whether you've got appropriate backup arrangements in place. But also the other thing to think about is that in the context of what is notifiable, the suspension of access in and of itself might not meet the threshold of notifiable if you're aware that the suspension of access is going to happen, if it doesn't have a detrimental effect to the individual. So if you know something's gone offline but it will come back online quickly, unlikely that even though it's a privacy breach, it's unlikely to meet the threshold of notifiable. And in that regard, you need to assess, well, there is a separate definition of what constitutes a notifiable privacy breach. So that is a privacy breach that it is reasonable to believe has caused serious harm to an affected individual or individuals, or is likely to do so. So would a reasonable person in the shoes of the individual whose information has been, say, misused or has been accessed by someone without authority to do so, would they be caused serious harm? And it's not an easy test. It can be quite difficult to assess. It's a slightly better test than was in the bill that was originally proposed, and we and a number of other submitters fought hard to get a more objective standard in there in terms of what might constitute a notifiable privacy breach. But ultimately, you do need to sort of step back and take a sort of look at the bigger picture when assessing whether or not a privacy breach meets that threshold. And it could be quite straightforward in some instances, because some information will inherently cause serious harm to someone if it's the subject of a breach. Of course, that still does depend on the nature of the breach. So, for example, if it's sensitive information, but it's been lost, but you actually didn't really need to hold on to it for any longer, perhaps you only had a legal obligation to record it, then that might not necessarily be a big deal for the affected individual, and therefore the threshold of notifiable might not be met. But yeah, certain information, financial information, health information, that sort of thing, almost always is going to tend towards being information which, if misused or lost, will cause serious harm to an individual. Other information, it's not always so clear. You do need to think about the context. So someone's phone number, someone's address, look, that's not inherently sensitive, say, but depending on the context in which that's been collected and the person about whom it's been collected, it could cause serious harm. So if that individual was well known, or if they're in witness protection, for example, the fact that their phone number or address has been leaked could very well cause that individual serious harm. So that's why it's really important to really understand the type of information that you do hold on your systems, who it's about, the purposes for which it's been collected, and what the worst case scenario could be if that information were lost. Ideal to do that before a breach occurs, so that you're ready and willing and able to respond quickly. And of course, if you're not clear whether the threshold of notifiable has been met, I think it's a good opportunity to proceed as if it is notifiable, to demonstrate that you do take your commitment to privacy seriously. So even if it does mean admitting to your customers or notifying the Privacy Commissioner that, yeah, you did have a privacy breach, the fact that you've taken action and you can explain what you've done to mitigate the risk to them, and you're treating it seriously, even though maybe they do think it is trivial, I think demonstrates a commitment to respecting the inherent sensitivity of any information about someone. So just by way of reminder again, once you do hit the threshold of notifiable, you must notify the Privacy Commissioner. And you must do so as soon as practicable after becoming aware of the breach. So some more useful stats that have come from the Privacy Commissioner. 33% of breaches so far have been reported to the Privacy Commissioner within 2 days, and 54% have been reported within 5 days. So it's interesting, you know, what is an appropriate time within which you should report? There's no suggestion that 5 days is not as soon as practicable, but you know, it's perhaps a bit longer than some organisations might have thought it would be. Certainly, it's going to depend on the circumstances. You know, 2 weeks, if you settle on it for 2 weeks, that's probably not quick enough, but there's no sort of clear line as to when as soon as practicable is triggered. It's interesting to refer to the GDPR, which specifies that the equivalent reporting obligation for privacy breaches arises without undue delay, and where feasible, not later than 72 hours after becoming aware. So there's no suggestion that New Zealand law is any more stringent than the GDPR, so 72 hours is not a bad little benchmark. But you also need to think about, you know, what other steps do you need to take to respond to a breach? You're sitting on a breach for 72 hours and doing nothing. That's certainly not going to do you any favours in terms of mitigating the potential risk to your reputation, for example. And along with notifying the Privacy Commissioner, you must also notify the affected individuals, or in some cases, the public generally. So if you can't easily identify the affected individuals. There are exceptions that apply to that. So there's no requirement to notify individuals where to do so would prejudice security or defence concerns of the government. would prejudice the maintenance of the law, would endanger the safety of any person, which could be quite relevant in the context of not wanting to make a breach worse. Where to notify individuals would reveal a trade secret. Quite difficult to conceptualise the circumstances where that exception may apply, but it's good to know it's there. And there are other limited exceptions that apply which are subject to conditions. So for example, if the affected individual is under 16 or if the disclosure might prejudice the health conditions of the individual, where you might have to instead notify a guardian, say, or a medical representative. Now, you can also delay notifying individuals, and it's important to note that that's a delay, that's not an exception to the obligation. But you can delay notifying individuals if notification would have risks for the security of the personal information, and those risks outweigh the benefit of notifying individuals. So that would be relevant in situations where there is an ongoing security issue that hasn't been fixed, and the fact that you may be publicising the breach could make it worse. But that ability to delay only lasts for so long as those risks outweigh the benefits. So what does that mean for you in practice? You need to be keeping a record of the decision, and you need to ensure that you're frequently reviewing that decision. So sure, you might make the decision to delay. You need to do so on the basis of an objective assessment of what the risks are of notifying. And you need to schedule in frequent reviews to make sure that when those risks no longer outweigh the benefits, that you're ready to notify. And then the question is, well, who does notify? Certainly when you've got a service provider involved, and we'll touch on this when we cover key terms of agreements with service providers, but you need to ensure that responsibility has been allocated properly. You need to be able to ensure that you can meet your obligations under the Act. Where it can get a bit fuzzy, I guess, is if there are two parties that have sort of joint or similar responsibility for the same or similar personal information, where there's maybe a bit of a hybrid arrangement in place where the other party is a service provider to an extent, but also uses the information for their own purposes. And to be honest, that's why it's important to have a plan in place. And you do that through your contractual arrangements, or you do that internally, or both, like you would for any other crisis that needs managing. So you need to be able to step into action pretty quickly. And that's not just to ensure that you comply with your legal obligations under the Act, but also to ensure that you can take steps to shut down the breach, to work with those affected individuals who are your customers, whose trust you might have lost, to ensure that you can mitigate the fallout of and the effects of the breach on your organisation and your reputation.
Thanks, Campbell. Hey, I've got a couple of questions that have come through that I'll just answer in terms of the section I talked about just before. So one question here, Australia not being a country with deemed sort of safe harbour for GDPR purposes, the question is, if New Zealand recognises it as having comparable safeguards under the New Zealand privacy regime, will this affect our status? And now I think in terms of Australia, it's a really great example. A couple of the key reasons it doesn't have the tick from Europe are around those employment records exception and the small business exception, noting that the small business exception threshold is about to change as well. So I think there's a risk if it's a blanket, Australia is good to go. Certainly the opinions that I've been giving for comparable have been saying that it's okay for this sort of information, but not, and for this sort of recipient, but not for the exceptions. And so it's hard to know exactly how the Office of the Privacy Commissioner is going to state whether or not a country is safe. It may be with exceptions, and for Australia, I think, would be prime for one of those ways of dealing with it. Another question here, when talking about prescribed countries for IPv12, obviously I mentioned EU, a question there whether we thought that it would be specific countries within the EU. Again, I haven't got any insight from the OPC as to how they're going to do it. I envisage that they probably will have to list countries. Some of you may be more familiar, having worked in Europe a little bit more recently than me, in terms of how the European Union laws filter down, but they do vary country to country. And obviously there are domestic laws which may counter as well, or mean that some countries are safer than others. So probably by country, but I haven't got the inside word on that from OPC. Campbell, assuming you haven't on either of those questions either?
No, I'd like to think that they'd treat the EU as one, but I suppose it's worth noting that any assessment that the EU does of any country's adequacy, they don't just look at privacy laws, they do look at the rule of law generally, and they can look into search and surveillance laws. Whether we'd take the same approach and want to assess all the, do a full assessment of all of the laws of Croatia and Belgium and etc. I'd like to think that we'd take a common sense approach and just give the EU a blanket approval, but that remains to be seen.
Yeah, who knows? Cool, so access to personal information. This is definitely a focus, a real target area for the Privacy Commissioner. Apparently over 70% of complaints to Privacy Commissioner relate to requests for access to personal information. So in terms of what you do in your businesses and organisations to deal with this, one of the easiest ways is to think about avoiding friction in terms of making it easy for people to be able to get their own information. A lot of time, effort and money can go into facilitating access requests. So certainly if you are designing new systems, designing new processes, and privacy by design is a great way of looking at this, ability for somebody to access their own information and then correct their own information as well, to the extent applicable, is definitely one not to forget. Now, if you don't comply, the Privacy Commissioner can now issue access directions, essentially requiring you to make the information available. Now, if you don't agree, of course, you can appeal to the Human Rights Review Tribunal. But if once the Human Rights Review Tribunal's looked at it, you don't act, they can then appeal and seek enforcement. And essentially an issue requiring you to do this from the tribunal is an access direction. Failure to comply with that, $10,000 fine. So there's a few processes involved, but most people who may get the bone and grab the bone and want to run with this will probably be quite happy to go through the process. So avoiding it hitting that point is useful in terms of time and money. There have been a few key changes to the access regime. In addition to jumbling all the previous provision numbers around, just to make my day a little bit more difficult, given all new numbers, there are a few new refusal grounds that have been brought in. These are primarily aimed at circumstances where the risk of harm arising from the disclosure, so whether to the requester or to a third party, is, for example, likely to pose a serious threat to life, health and safety, or to public health and public safety. Now, it is a high threshold. I do urge caution in terms of using these. It has to be real. But there's been a bit of a beef up in that area. Another area where there's been some change is around evaluative material. It's been clarified that refusal ground for evaluative material includes material made available by another agency. So that was always sort of assumed but not clear. So that's been clarified. But there has also been a new exclusion from the definition of evaluative material. It doesn't include evaluative or opinion material that is compiled by a person employed or engaged by your agency in the ordinary course of that person's employment or duty. So previously, evaluative material, particularly in the context of employment, particularly employment, but other where you're evaluating people, there was a general ability to carve out quite a lot, including by your business, the business yourself. But that has certainly been pared back. So one to note if you haven't noted it already. There's been a bit of modernisation of the language as well. Thinking a lot of that was probably inadvertent changes. Certainly there wasn't a lot of song and dance around that. For example, there's no longer express refusal for information that isn't readily retrievable, but it's still one of the options for responding. So it's probably not intended to be removed, but just in the juggling around, there's been a little bit of tweaking. But in some places we're thinking it wasn't necessarily a big change. The biggest thing with access to personal information, though, as you can imagine, is that tricky question of what constitutes personal information. A lot of the assistance we're providing, and we end up doing a lot in the employment space with our employment team, is around that phishing when you've got an employee that's not happy and what they are entitled to and what they aren't. Information about an identifiable individual. There's obviously lots of scope to argue about what about means. Taylor versus Correction was recent case law where information about corrections staff members appearing in Mr. Taylor's files was not found to be information about Mr. Taylor. So that sort of pushed the threshold in one direction. But the Privacy Commissioner's view, as you can probably imagine, is definitely a broader interpretation of the term about than that given so far by the courts in that context. So it's definitely a moving feast. What should you do in terms of access requests to make your life easier? I think it starts with implementing really good retention practices and policies. And by that, I also mean non-retention. There's a new offence for shredding or the like, destroying information once it's been requested under an access request. And obviously, I'm not saying shred at all. There are very good reasons to keep information. There's very good a responsibility to keep information, both legal, potentially contractual, and simply commercial. But some thought needs to go into it. And generally, this is an area of weakness for most organisations that we see in terms of the life cycle of information. In terms of training and getting your staff to not end up with the smoking gun sitting in their email piles, we would say dance like no one's watching, write an email like it might be read out in court, or essentially hand it to the person you've just written it about. So really raising that awareness. There is still that idea that an email can be deleted, and of course it can't be. If you don't want something disclosed, picking up the phone is a much safer thing to do, and just making people really aware of this. Given the increase in work from home, I think a lot of emails are flying around, and those emails might be emails that would otherwise have been, just a simple discussion taking place, which is obviously a lot harder to have to provide in terms of an access request. And I guess the other thing in terms of how you should tactically be dealing with access requests is establishing the work required. So if you are getting very broad requests, and you're in a position to be able to have a sensible discussion with the person making the access request, having an upfront discussion with them about what's easy to access, what's less easy, and the costs involved. And albeit there are quite considerable limitations on the amount you can charge, you still can charge for reasonable costs. So that can help with deterring phishing and making sure that actually access requests are being used appropriately.
Okay, so just moving on to the last new topic we're going to talk about today before we dive into agreements. But the Privacy Act now applies with extraterritorial effect. So this is quite an interesting one. It applies to an overseas agency in relation to any action taken by that overseas agency in the course of carrying on business in New Zealand in respect of personal information collected or held by that overseas agency. The test isn't as clear-cut as it seems, because there's a lot of meaning tied up there in the term carrying on business. It's not actually that clear what it means to carry on business in New Zealand. That test is seen elsewhere in New Zealand law. It's seen in the Companies Act, but it's quite a different test. There's a lower threshold, it would seem to appear, in the Privacy Act than is set out in the Companies Act. And an agency can be treated as carrying on business in New Zealand without necessarily being a commercial operation, without necessarily having a place of business in New Zealand, without necessarily receiving any monetary payment for the supply of goods or services, and without intending to make a profit from its business in New Zealand. And it's useful to read the parliamentary debates about exactly what the intention of these extraterritorial provisions is. And there are multiple references to overseas-based online platforms that the law is intended to capture, such as Facebook. So that gives you a sort of a bit of colour as to what the term carrying on business was meant to mean. The Privacy Commissioner has also released some guidance, although he's released this guidance in the context of IPP12 and what you should take into account when making a disclosure to a foreign person or entity if you want to rely on the basis that that foreign person or entity is subject to the Privacy Act. So a bit of a backdoor kind of piece of guidance there from the Privacy Commissioner. So he and his office will take into account whether or not the organisation is undertaking activities that involve the collection, use and disclosure of personal information on a repetitive, systematic or continuing basis. So that makes sense, when there's an ongoing relationship, I guess, with New Zealand, then it should be assumed that New Zealand law is intended to apply. Where the organisation has a website offering goods or services to countries including New Zealand or specifically targeted at New Zealanders. So that's an interesting one. Certainly when you look at the EU test, as far as it applies to extraterritoriality, what does offering goods or services to countries including New Zealand mean? How far do you have to go? A lot of websites are sort of open to all comers, right? So it's still not that clear exactly what that could mean in the context of those sorts of websites. If the activities take place or are acted upon in New Zealand, and again, that sounds fair enough, although again, we live in a digital environment where most transactions take place online. And those activities don't necessarily take place or are acted upon in New Zealand, where servers are located in another jurisdiction, where individuals who are processing the information or collecting the information aren't actually located in New Zealand. And the other thing the Privacy Commissioner is looking to take into account is whether or not the organisation is the holder of trademarks or has registered web domains in New Zealand. Which I think is probably a little bit of overreach, or certainly that in and of itself is unlikely to be enough to establish that someone is carrying on business in New Zealand. So watch this space. Look, it'll be interesting to see if and when we have any regulatory action, bearing in mind the cost of trying to enforce New Zealand law extraterritorially against some of these online businesses overseas who are quite large. Certainly, the Privacy Commissioner will be looking to the Commerce Commission's interactions with Viagogo and how difficult that was to enforce fair trading law. But the first case is going to be interesting, is all I can say.
Cool. Now, before I hit this next one, some interesting intel. Thanks. I'm not sure if I'm allowed to say people's names, but Jonathan. So he had a colleague attend a seminar by John Edwards the other day, and he apologises for the hearsay. So this is definitely getting hearsay. It's me reading off somebody else's, but apparently they're working through adding countries to the IPP12 whitelist, which I guess we'd be hoping. And one country they're assessing is Germany. So that obviously suggests more of a country by country than just a blanket EU approach. And that this assessment is taking longer than expected, i.e. at least 6 months, which also I guess suggests that they are actually looking quite in depth. Either that or they're very slow readers. I'm not sure which. Hopefully it is that they're going deeper, and that they're probably though not going to be able to do the 1 to 2 countries a year, which yeah, certainly doesn't help with having this as an avenue. Anyway, thank you for that intel. So what should your agreements with service providers look like? So in terms of this, we're talking essentially you as controller giving out to a processor, just to use GDPR kind of language. Now, in this context, what we're talking about is processing as an agent for another agency. Essentially, what we're talking about here is not a disclosure. So IPP11 and IPP12 don't get triggered. You're deemed to continue to hold the personal information yourself. So that's quite useful in terms of not having to tell somebody that you're transferring the information in terms of IPP3. But obviously, you're still fully responsible for everything they do or don't do in relation to that information, including IPP5 around security. So don't just require your service provider to comply with all privacy laws. That's pretty vague. In New Zealand, the Privacy Act doesn't really kick in for processors, which again is a distinction from some overseas jurisdictions. So the obligation is on you. And so how you draft those sort of compliance with law provisions needs to be considered in that context. Rather, we tend to focus on having some language like that, but also establishing what you actually need from the service provider in order to assist you comply with the obligations under privacy law. And that's going to be quite contextual depending on what they're actually doing for you. And it can get a bit tricky if they're also collecting information on your behalf. So looking at that life cycle, understanding the data flows, the information flows, and what's actually happening, and clearly articulating in their contract drafting, and also in terms of your reviews as to whether or not it complies, is quite important. That said, requiring compliance with privacy laws is obviously a good place to start, and certainly we wouldn't say just not having it there is a good idea. But then set out very clearly that the service provider is acting as your agent and confirm, what the scope of their agency is. We note that there can quite rightly be reluctance to use the word agency or agent. It does have connotations with it, legal connotations. So we're tending to use solely on your behalf and solely for the purpose of providing you services as a way of meeting the threshold without actually using the word agent. We know, obviously, as well in this context, and particularly when you're talking to, your commercial team and stuff, it's very unhelpful that the Privacy Act does refer to everyone as an agency, and then you've got to deal with, acting as an agent of an agency. So, yeah, that just adds another layer of complexity in there. So what can you say? Certainly instruct the service provider to only process personal information on your behalf and for the sole purposes of carrying out the service to you. As I said, that's a clear, definite, make sure it's there. limit the service provider's ability to modify, amend, alter, other than where it's consistent with the purposes that that they need to for carrying out the services. So having some limitations. And I guess one of the more difficult areas that we're obviously getting questions around, and it's been sitting there as an issue all along, but certainly IPP12 and greater emphasis on the Privacy Act is bringing it more to the fore, is around the crossover, to the extent that somebody essentially is providing you a service, but maybe doing a little bit for themselves. And that little bit for themselves often relates to things like improvement of the service, or, you know, quite close, but, you know, is it really for you or is it really for them? And that does need a bit of thought. Thinking carefully about at what point the anonymisation, aggregation of the service, of the information by the service provider occurs. You know, is that as your agent? You know, can you rely on, you know, it being very clearly anonymised, aggregated, so that it really does get outside the definition of personal information? There's a few ways of dealing with it. It is quite fact specific, but that's certainly a pinch point in terms of finding that there. So if you do find that pinch point, or if you're not sure, you know, do you then deal with, well, to the extent that you're a controller, and making sure that you're complying with the likes of IPP12 and IPP11 as well? And I would say yes. And you can do that. Obviously, you can still have that. You can only use the information for these specific purposes, and you can use it for this extra one. And to the extent you're using it for this extra one, and you know, you will continue to comply with the Privacy Act, even if it doesn't apply to you. Perhaps lead on the model clauses, have those model clauses perhaps kicking in, if to the extent they do end up using it for themselves. So a few ways to roll with it. Obviously going to be quite contractual and factual specific, but certainly that's a pinch point. Other things to think about, not necessarily that you have to have them in the contract. Certainly it's not a requirement for compliance with the Privacy Act, but other really key areas to think about: geographical limitations on where the services are to be provided from. Now, this isn't because of IPP12, because obviously these are not disclosures as such, but more around your IPP5, you know, where the information is stored and what other laws might be being implied into the relationship. Does, you know, go to how secure you are keeping it, and whether you are doing the due diligence you need to do. While you can disclose if required by law of another country, you know, do you want to tell your customers that you may also need to disclose under XYZ's laws? Probably not. You can also impose contractual restrictions on further transfers to a subcontractor, particularly, you know, it's quite justifiable in terms of making sure you are keeping that control and doing that due diligence on who has got your information, because again, it is you that's holding it, even if it's passed down the chain. So really wanting to limit that chain if you can. A core obligation to implement appropriate measures to avoid a privacy breach is that IPP5. So from a practical and from a contractual perspective, can you get some confirmation? Certainly in a lot of the space that I play in financial sector, you've got a lot happening with the likes of CPS 224 and APRA's requirements, etc. So it's more and more, particularly technology and outsourcing and service providers are being very open and transparent around, because they have to, around audit rights, the kind of compliance that they've got, and essentially due diligence is becoming more of a norm for somebody procuring services. So don't feel as though you'll be asking something that's unusual. Make sure you do it. And another one to think about is who's responsible for backups. And I often think, you know, when you're reviewing contracts, you know, how many questions should you ask? If there isn't somebody in your business that's asking all these questions, I guess it falls on you guys. So, you know, no question is too stupid in terms of understanding what's going on with the data, so that you can make sure the right provisions are included, both contractually and then also practically, making sure you're complying with IPP5.
So when it comes to notifiable privacy breaches, or privacy breaches generally, this is where the requiring a service provider to comply with all privacy laws kind of falls down. So requiring a service provider to notify you in accordance with applicable law if a notifiable privacy breach occurs doesn't necessarily work, because there is no direct obligation on a service provider who holds information on your behalf. You're deemed to hold that information, and therefore the obligation to notify falls on you. So you need an express obligation in there on the service provider to notify you when a breach occurs. and you need to be careful with the drafting to make sure that it's clear the circumstances in which you're expecting to be notified. I've seen some examples of where the service provider will notify of a notifiable breach, and I don't think that works. I think it's incumbent on the person who collected the information, who has the relationship with the customer and the affected individual, to actually determine whether the privacy breach or not reaches that notifiable threshold. And then, of course, how soon should notification take place? Well, the Act requires you to notify the Privacy Commissioner as soon as practical after becoming aware of the privacy breach. And you can't notify a privacy breach if you don't know that it's occurred. But there's a bit of ambiguity there in the terms, because you're deemed to hold the information held by a service provider on your behalf. Do you know that the breach occurs when they know that it occurs? I think it's safe to assume that that is the case. Which means that you should be requiring your service provider to report privacy breaches that happen as soon as practicable after they become aware of it. And then setting in a time frame, like say, for example, in any event within 24 hours or 48 hours, which gives you a bit of time to then make an assessment before you take the next step, if it does indeed amount to a notifiable breach. And of course, it's not just a question of regulatory compliance. So the sooner you know that your service provider has suffered a breach, the sooner you can mitigate the potential reputational impact to your organisation, especially the impact to the affected individuals. What else should you be requiring your service provider to do? I think it's useful to have an express obligation on them that they will cooperate with you in connection with the breach and provide you with all the information you need to respond appropriately and in a timely manner. And also just generally cooperate with you in respect to investigation, complaints, access requests that are made under the Privacy Act against you, because they'll be made against you. You won't be relying on the service provider who's your agent to respond to some of these, to retrieve the relevant information. So you're going to need their cooperation to meet your legal obligations. So then it's a question of who pays for this assistance. And that might depend on who's responsible. So obviously, if there's a privacy breach caused by the service provider, you'd expect them to soak up the cost. But if you're the subject of an investigation or a complaint or an access request, might be a bit harder to justify passing on the cost to your service provider. But then again, that's going to depend a lot on the fee structure you have in place. Something to think about. And finally, when you're looking at agreements with your service providers, should you be thinking about indemnity protection? What sort of indemnity protection is appropriate? You need to think about, to what extent you might be able to get indemnity protection. Certainly, if there's a privacy breach in particular, you're going to be incurring costs notifying affected individuals. You're going to incur staff time communicating with the regulator, for example. It's not that unreasonable to seek an indemnity for that sort of cost. Question of whether, bearing in mind the low level of fines under New Zealand law, could you get an indemnity for fines? Would that even be enforceable on public policy grounds? And then think about the other sort of loss that you might be suffering. So the loss of goodwill, the loss of revenue, the loss of customers that you're likely to suffer as a result of a breach caused by a service provider. Then again, is the service provider ever going to agree to step up and indemnify you for that liability? That's where you also need to think a little bit about insurance cover, whether or not you require your service provider to hold cyber insurance, say. And in that regard, you'll need to check what that policy will cover. And also think about your own cover too. Don't necessarily assume that the service provider's cover will step up to the mark in the case of a breach. All right, now I said we'd get some bonus topics and we've got 4 minutes to cover them. So we are going to rattle through them pretty quickly. Just a quick run through. But just a comment about privacy officers, and we're getting a surprising number of inquiries from both New Zealand and international organisations about the requirement for privacy officers. Just like to say, this is not a new requirement. This shouldn't come as a surprise to anyone, but it's obviously becoming a bit more pertinent now that we have a new Act and the Commissioner has new enforcement powers. And privacy is much more important, I guess, for organisations than it was 28 years ago. New Zealand law is a bit different in that it doesn't require the privacy officer, or in some jurisdictions referred to as a data protection officer, to hold any particular qualifications, nor do we require the registration of the identity of the privacy officer. What it does mean, though, is that you do need to know within the organisation who the privacy officer is, or alternatively who the privacy officers are, since the role can be shared. Because if there is a problem that happens, then you need to know where to go. And certainly if the Commissioner comes knocking on the door and you don't know who your privacy officer is, that's not going to present very well. We do often find with smaller organisations, the role of privacy officer often falls on legal counsel. It's not necessarily the right thing to do, but certainly legal counsel can be some of the better placed people to assume overall responsibility for the role. And bear in mind that the Act now expressly contemplates that you can actually outsource the privacy officer role to someone outside your agency. So there could be someone in a privacy function in another jurisdiction who's perhaps better placed to take on the role of privacy officer. But then again, they can only properly discharge their obligations if they're encouraging compliance and understanding the obligations under New Zealand privacy law. But whatever happens, you do need to make sure that someone owns that privacy responsibility, because again, if the privacy commissioner does come knocking, you can't even identify who your privacy officer is. That's really going to set you up badly. It's pretty indicative of the fact that you don't know what you're doing when it comes to privacy compliance. Just a very quick topic, discussion of consumer data rights, which is sort of a privacy topic, sort of a competition law topic. MBIE's currently consulting on consumer data rights and looking to probably take an industry by industry approach. We're talking about a concept of sort of data portability here, where personal information about you or information about you that's been collected by a service provider, you have an ability to extract that and effectively flick it off to another service provider to help you shop around a little bit. So this is coming. It's already sort of been seen in the electricity industry at the retail level. Open banking is another sort of consumer data right concept that's been embraced. So bearing in mind the fact that it is coming, you need to think about when you're developing your products and services and systems, how could you facilitate compliance with the consumer data right if you had to? How can you build your databases so that the information you have about a customer is easily extractable, so you could provide it to someone else or to the individual for them to then provide to someone else, if you had to. And take into account also access rights as well. It helps you with self-serving a subject's or an individual's right to access their own personal information. It's going to make life easier if you cut down compliance and administration costs. Looking a bit further afield, we did have a UK decision earlier this year, which was quite good for, I think, New Zealand-based businesses, certainly those with an online presence. The court found that a US publisher's website, even though it solicited donations in pounds and euros, accepted UK shipping addresses, placed cookies on readers' devices, so was tracking their behaviour, did not actually mean that the US publisher was offering goods and services to an individual in the EU. And therefore reached the conclusion that the GDPR did not apply to this US-based website. Now that seems a little bit at odds at some of the guidance we've had to date, but it certainly means that the threshold that needs to be met before the GDPR would apply to online businesses that don't necessarily target the EU-based customers. It means that their threshold might have moved. Then again, you need to look at the context. It's a UK decision, so not really sure how much weight that will have post-Brexit. Not sure that the EU courts will really care what the UK courts have to say. And in any event, EU and UK-based consumers are going to expect a certain level of privacy compliance, whether or not the law technically requires it. So the way you do business towards EU and UK-based customers will need to take into account what's the current practice there anyway. And finally, a little discussion on adequacy, which we touched on briefly on our discussions around whether or not we might bring Australia into the prescribed countries list. For the time being, the UK has decided that we are adequate for the purposes of the UK privacy law. There's now a UK Data Protection Act and a sort of UK equivalent of the GDPR. And the reason they've done that is because the European Commission thinks we're adequate. And the European Commission does still think we're adequate for the time being, and they are reviewing this. They're constantly reviewing this, so it's not guaranteed to stay in place. Watch this space, and again, when we start making decisions about prescribed countries, that may or may not have an impact on whether or not we continue to be adequate. And interestingly, the European Commission provisionally thinks that the UK is adequate now that it's left the European Union. Although a final decision is yet to be made, it's a bit surprising that you think a former member of the EU would not be adequate. But the UK has always had a bit of a problem when it comes to the EU and it's the UK snooping laws. So that's the rights given to search and intelligence and security agencies to intercept communications primarily. the EU's never been a fan of that, and they see that erodes privacy rights for citizens. So therefore, it's not a done deal that the UK will get a decision of adequacy found. Now, look, if you've enjoyed today's session, there's a few more resources available to you. We've got a few articles, and we're constantly releasing new ones. So if you'd like to be added to our distribution list, please let us know. And there's a few other webinars that we've done over the course of the past 12 months. So Hayley's comprehensive dive into the Privacy Act in the last year, and then a session I've done on the GDPR and what it means for New Zealand businesses, which are available through those links. And these slides will be made available to everyone at the end of the session as well through iLands. So you'll have direct access to those links. But I think we're sort of running out of time. I don't know if you want to take any questions now, Hayley, or shall we?
I think we probably have run out of time. We've got some great questions coming through, and as I did on the session last time, we will bundle them into a doc and just provide some answers and circulate so that everyone can hear them, because there are some great questions coming through. So thank you all for listening. Have a great rest of the day. If you do want to pick up the phone to us at any point, contact details are conveniently right there, and we're always happy to chat privacy. We love privacy, don't we, Campbell?
We do indeed.
We do. Cheers, guys. Have a great day.